afternoon, and thank you for joining this webinar on Back to Basics to Protect Your Business, specifically focusing on credit control essentials. I will start the webinar promptly, as I appreciate it's lunchtime, and obviously you will wish to go off and have some lunch at some point. Hopefully the webinar will take around 20 minutes, so it shouldn't take up too much of your time. And I'd like it to be as interactive as possible, so I believe you have the ability to raise your hands and ask questions throughout the webinar, or alternatively there will be a time at the end for some questions if there are any. So firstly, a little bit about Bracious and myself. Just move the slide forward. So there you go. So Bracious is an award-winning law firm. We've been in existence since 1895, and we celebrate our 130th anniversary this year. Renowned for building long-lasting relationships. I've been with the firm since 2002 and have some clients which I still act for today, which I acted for when I first joined. So we do have long-standing clients. Earlier this year, in fact, we joined the Law Front Group to assist with moving the firm forward to realising the bold ambitions we have and continue to grow. Myself personally, as I said, I've been with the firm since 2002, acting or working within the debt collection department specifically, and latterly working with insolvency matters and acting for insolvency practitioners, liquidators and trustees in bankruptcy. So I'm well placed to assist with credit control procedures, and in fact we do offer a process where we can specifically go through credit control procedures of the client and suggest some changes. So that's about Bracious and myself. So let's get what you're all here for, credit control. So in terms of credit control, well, credit control starts not just when an invoice falls due, but it starts right at the inception of an agreement you have with your client or you have with your customer. So if we look a little bit further into what I mean by that, you may have a contract with terms and conditions, and you really should have a contract with your terms and conditions, but what terms and conditions should you look to incorporate within that agreement to protect yourself, specifically in relation to the credit control process at a later date? How can your terms and conditions best protect you when if push comes to shove, you need to then undertake legal action? Well, in that sense, there are two, and it seems very sensible and it seems very common sense, but might be missed, that you should have clear payment terms within your terms and conditions as to what and when payment should be received once an invoice has been rendered. It's, as I say, seems common sense to say, but in many cases can be missed. Equally, do your terms and conditions record where payments should be sent? I have had two cases recently where a case of invoice fraud has taken place. Somebody has intercepted an email, changed bank details, and the payment has ended up with a fraudster. Although in both cases the clients obtained payment eventually from the third party or their client, it did take a long time, and in one case it took a lot of effort through the courts and a lot of costs. So if your bank details are recorded clearly in your terms and conditions to start with, then that issue could be avoided. One other consideration to think about is, do your terms and conditions include the ability to recover interest or costs if payment isn't made of an invoice and you need to pursue further action? In a commercial situation, it is likely that you'll be able to recover interest and compensation and costs pursuant to the late payment legislation, and that by that I mean the Late Payment of Commercial Debts Interest Act, whereby you could recover interest at the rate of 8% above the Bank of England base rate, and also compensation on a sliding scale pursuant to the value of your invoice. The compensation is either 40, 70 or £100. That piece of legislation also allows you to claim the reasonable costs of collecting the debt if those costs are not covered by the compensation. And the compensation is per invoice, not per amount outstanding. So that's something worth considering. So if you have the ability within your contract to claim interest and compensation, you should then use it if an invoice goes outstanding and not paid on returns. So once you have your all singing, all dancing terms and conditions, certainly in respect of credit control processes, how do you then have that incorporated into your agreement with your client customer? Well, frankly, you need to give notice of those terms and conditions to the customer before you contract with them, before you agree to undertake any services. Your customer should have the opportunity to review those terms and conditions and should have the opportunity to question and raise query with any of those conditions they don't agree with. That gives you the opportunity then to decide whether you do contract with that customer client, or whether you then take a step back and say, no, our terms and conditions are more important than your business. Ideally, and I'll touch on this in a moment when I'm talking about the sales team, but ideally the terms should be signed. If they aren't signed by your customers showing agreement, you should have evidence that those terms have been sent to your customer client, so they can then show that, also you can then show at a later date, if necessary, that they've had sight and understand where those terms can be read and have contracted with you regardless of that. I would also at this point flag up the battle of the forms. This is a position whereby you may have provided your terms and conditions to your client customer, and in response they send back their terms and conditions. The general rule is that those terms and conditions exchanged last will be the ones that take precedence. So if you have all singing, all dancing forms, but you fall foul of terms and conditions being sent back by your customer, it is very likely that their customer's terms and conditions will take precedence and you will not be able to rely on yours. So that is something to consider about. That's something to make sure your terms and conditions do apply to your agreements with your clients. So let's just move on to the next slide. And I mentioned this just earlier, that this slide is in respect of your sales team, and do your sales team appreciate the importance of obtaining necessary agreements from your client customer, or are they simply interested in obtaining commission and ignoring what might come next because it's somebody else's problem? The sales team is your first contact with the customer in most cases, and it's the chance to implement effective credit control process. So what do I mean by this? And this is from a credit control process, not necessarily from the sales process, but firstly, do your sales teams confirm the true identity of your customer? From a legal point of view, where a case is handed to us to sue on, we need to know what the legal identity of the debtor is. So for example, if it's a limited company, does your sales team obtain the registered number of that company, the registered office of that company? If it's an individual trading as a trading identity, do they obtain their full name? Do they obtain, for example, in that instance, their date of birth, their address? Again, if it's a partnership, it's all this crux of information which is required. Sometimes we have seen client account forms passed to us to sue on, where it's Joe Blogs, and we don't know if it's Joe Blogs Trading as, we don't know if it's Joe Blogs Limited. So that is key when your sales team obtain any signed documents, but we know exactly who the or what the legal identity is of that client. Again, it may seem straightforward, but we really do need to know all contact details for your client, emails, addresses, any other way to contact them. Knowledge is power in this game, and if you have all that knowledge at that point, then when it comes to a later date, and if you need to pursue payment, you can have all that information, and it makes matters more straightforward. Once you have that information, do you then run credit checks to see if your clients are credit worthy to make payments of any credit which you afford them, or if not, do you ask for money on account before you contract with them? So many times credit applications are completed, no credit checks are undertaken, and then of course then that leads to a problem at a later date. And it's linked also to obtaining a credit check. Do you then ask the director to sign a personal guarantee if you're contracting with the company? The personal guarantee doesn't have to be used if the company makes payment, but if an unexpected situation occurs and the company goes into liquidation, if you have a personal guarantee from a director, you can then rely on that to take a step back and pursue payment by an alternative means, not just through the company. So that's something to think about, and certainly something to train your sales staff on. So once you have your terms and conditions incorporated into your agreement and you've obtained all the necessary information, and regardless of that payment still doesn't get made, what sort of credit control process should you be looking at? Well, there's no general rule of thumb. It really does come down to the needs of your business and the needs for your turnaround and your cash flow. But if I were to be asked what sort of credit control process should be used, you should probably be looking at something along the lines of a couple of days before the invoice falls due, sending an email, phone call just as a gentle reminder. Same once the invoice is then due. 7 to 10 days thereafter, sending a formal letter confirming the invoice is due and seeking payment terms. And then a mirror approach 2 to 3 days later, picking up the phone or sending an email. 7 to 10 days after that, sending a more formal letter, possibly a letter of demand at that point. 2 to 3 days after that, another phone call, email, trying to engage. And then if you haven't in your previous letter, sending another letter saying you're going to be taking further action, be that instructing solicitors, be that undertaking your own claim on the court system. Now, such a credit control process won't be correct for all your clients. You will know your client base, or should know your client base, and the long-standing clients will require a different approach. But the vast majority, I would suggest that this is a suitable credit control process. One point I would say is if you make a threat to take matters legal, then you should stick to that. If you don't stick to a threat and you do nothing after making a threat, then it can get around your client base, but that is the case, and people will thereafter just continue to ignore threats. So if you make a threat, stick to it. Either instruct us to act for you or undertake your own legal work yourself. But one way or the other, always stick to your threats. Just moving on to the next slide. But of course, credit control doesn't just have to be a stick to beat your clients with. It can also be an effective way to build your business. If credit control is undertaken in the correct way, it will show your business as professional and will hopefully build a good reputation within your industry. It allows for a good communication to be built with your clients. You can get to know your clients, maybe even on a personal level. You can certainly get to know clients who need further assistance, who can't pay rather than won't pay, that the right way round. And it might even build further business opportunities, so you can discuss outstanding invoices with your clients, but then you can equally discuss potential for future sales once those invoices have been paid. It also hopefully will give a good indication of any troublesome accounts which may have to be taken out of credit control process and dealt with in a different way. People who don't pick up phones, people who don't answer letters or emails, you might have to consider whether you push those to a legal process at an earlier date, or you look a little bit deeper into why that isn't the case, checking company's house, for example, and seeing if there's any indications of any issues with that company or client. So, as I say, credit control isn't just a way in which to chase payment, it can also be used in an alternative means for your business. So although not strictly credit control, I will touch on briefly what the next steps are if, despite your credit control process, you still have an outstanding invoice. Well, the next, subject to the value of the debt, the next sensible step would be legal proceedings through the county court with a view to obtaining county court judgment, which you could then enforce. And as I mentioned earlier, knowledge is power in this game. If you have all the contact details and information on your client, you will know which cases are worth investing in to see whether you can obtain a judgment which you can then enforce. Although I said don't make empty threats, the court fees for cases aren't cheap, as you know, hopefully be aware. So you need to know the right cases where you should invest a court fee to obtain the judgment which you can then enforce. So if you have contact details for an individual, for example, you could check the land registry to see if they own a property. If you have details of the company, you'll be able to go into company's house, check last filed accounts. You'll also hopefully have credit checks, which may flag any issues as well. So that will give you an indication as to which clients to invest, as I said, the expensive court fees on, and which clients to maybe put to one side and flag as no further business with them. Another alternative route forward, which shouldn't strictly be used for debt collection, but so often is insolvency petitions. So by that I mean winding up petitions against a company and bankruptcy petitions against an individual. The winding up limit is £750, whereas the bankruptcy limit is £5,000, so a little bit more to make someone bankrupt. This is viewed as the nuclear option. You have to serve statutory demands, on both before pursuing petitions, and that does often help flush out which clients truly want to pay and which clients want to avoid being made insolvent, rather than the ones that just can't pay. But insolvency petitions, as I say, are a nuclear option. They're quite expensive. There's an official receiver's deposit for both of several £1,000s. That provides a fighting fund to the official receiver to take matters forward if orders are subsequently made on your petition. The hope would be that the nuclear option would frighten the person or company into reaching an agreement with you and making payments. If they don't, and you take the matters all the way through to winding a company up or making a person bankrupt, then at that point all other creditors come into play, and your claim in the liquidation or bankruptcy estate would form a part with all other creditors. And then if there are any asset realizations, which I'll come on to in the next slide, you'll obtain a dividend payment if there are sufficient realizations. So the hope would be, if you issue an insolvency petition or statutory demand, that you'll get paid, but it will not necessarily is the case. And it might be the case that a customer becomes insolvent during your credit control process, company going into liquidation or somebody going into bankruptcy. And as I mentioned, if you make somebody bankrupt or wound up, then it's not necessarily the end, as it is if a customer just undertakes that route themselves. As I said, you file your claim within the liquidation estate, and then in my view the best option is to sit back and internally write off the debt with the view that you won't get anything back. But it can be many months, if not years, that you may receive an indication from an insolvency practitioner that a dividend will be paid. It should be viewed, as I say, as a bonus rather than an expectation, certainly on most cases, unless there's specific knowledge of a large asset there which needs to be realised. Insolvency practitioners have powers over and above those of creditors, in the sense that they can review antecedent transactions, they can see whether there's been any movements of funds to and from other people, other companies, other individuals, which they can apply to court to try and set aside for the benefit of the liquidation estate or the insolvency bankruptcy estate. In a company situation, officers of the company can be investigated, and they can consider, insolvency practitioners can consider whether there's been any wrongful or fraudulent trading, which can lead to claims against those directors on a personal basis. That again can lead to a claim and an introduction of funds into the estate. Equally, if it was an individual insolvent who's gone bankrupt and they own a property, the trustees in bankruptcy have the power, also I've just changed slides, trustees in bankruptcy have the power to, correct slide, have the power to apply to court to sell that property. Generally speaking, the trustees can't do anything for the first year of the bankruptcy, which is why I referred earlier to the fact you should write off internally the debt and consider any payment as a benefit if it comes in at a later point, because it could be many years after the bankruptcy process has been undertaken. Just moving on to the next slide then. I should also mention that there has been a consultation recently, then there seemed no sensible place to put it other than at the end. There's been a government consultation about late payment recently. It ended, I think it was 23rd of October. We're still to hear, as it's very early yet, whether that will lead to any legislation. But the main thrust of the consultation was looking at larger companies and their payments terms and how long it takes them to make payment of an invoice. So what the government was particularly asking for questions on, or answers on rather, was board level scrutiny, so mandating that large companies and audit committees or boards review and comment on their payment performance, so putting them under the spotlight. Payment term limits, setting maximum payment terms capped at 60 days and then reducing hopefully to 45 days, making it statutory interest mandatory for suppliers to recover interest on late payments. Now, a lot of these, if you have your own payment terms, if you have your own statutory interest or your own interest terms, it's not going to be wholly relevant. I think this is a catch-all provision for people who don't necessarily have terms and conditions which help them. They're also looking at a dispute resolution method, which may or may not also work alongside the court system. Stronger enforcement to levy fines on persistent late payers. And in the construction sector, they're looking for specifically addressing the use of retention of title clauses in construction contracts. Now, as I say, this is purely a consultation which is now finished. We don't know if it will lead to any legislation. Certainly the government seems to be incredibly busy at the moment, so whether it will even get discussed at the beginning part of next year, let alone any later time, we will find out. But it's something to keep an eye on. It is aimed merely at the larger companies, so the Tesco's of this world, for example, to basically clean up their acts when it comes to making payments. Whether it will lead to anything, we will find out at a later date. So the final message I have is know your client. Knowledge is power in the debt collection and insolvency game. What do you know and what you can pass on to lawyers or to your credit control team is vitally important. Get everything right at the first point of call with your sales team, and then everything later should be a lot easier. So I hope that has been a useful webinar. Please let me know if you have any questions and I'll see if I can answer them. If there aren't any questions, then I will, it doesn't appear to be, by all means, my contact details are available and I can share those. Then you can email me with any questions you may have. But if you have no questions, then hopefully you'll have a nice lunch and hopefully I will speak to you soon. Thank you.